Welcome back to the Divorce and Child Custody discussion. I'm your host, Brian A. Victor. I'm a family law attorney, mediator, and someone who has worked with thousands of parents navigating one of the most stressful processes of their lives. Today's episode is one I feel very strongly about. Why FCS prep is not optional, it's mandatory. However, before we get started, I do want to take a moment to thank my loyal viewers, as I do every episode. You, the viewer, are the reason I produce this video. So thank you so much for your continued support, and remember to click subscribe so that you don't miss any upcoming or past episodes. As always, thank you to Feedspot. They named this podcast one of the top 15 divorce podcasts to listen to. And a huge thank you to Million Podcasts. They named this podcast number one on their top 30 best child custody podcasts. And remember, as always, the goal of this podcast is to educate, and nothing here constitutes legal advice or creates an attorney-client relationship. Now, before talking about family court services preparation, it's important to mention that when there's a custody dispute in California, parents are mandated to go to mediation to discuss parenting plans. More times than not, this occurs at Family Court Services, or FCS for short. I worked at FCS in San Diego for nearly 12 years and met with nearly 7,000 families during that time. And I can tell you from my experience, the FCS mediator has a lot of power when it comes to drafting a parenting plan report to the family court judge. Therefore, it's extremely important you get it right when you appear at Family Court Services. If you're walking into Family Court Services without preparation, you are walking into one of the most important custody conversations of your life completely unprepared. And I don't say that to scare you. No, I say that because I've seen the consequences of parents who assume, I'll just tell my story, the truth will speak for itself. The mediator will figure it out. I hate to break it to you, but that's not how this process works. Today, I'm going to explain, 1, what FCS really is. 2, what people misunderstand about the process. 3, the biggest mistakes I see. And 4, why preparation can literally change the outcome of your custody case. So first, what is FCS? Let me start with the basics. In California, Family Court Services is the mediation process parents go through when they cannot agree on custody and visitation. This is not therapy. This is not informal mediation. This is not a friendly conversation. Depending on your county, the mediator may make recommendations to the judge, and those recommendations carry enormous weight in many courtrooms. The judge is going to read the FCS recommendation before anything else. So let that sink in. For many parents, FCS is the most influential custody moment outside of trial. And yet, most parents prepare more for a job interview than they do for FCS. So, what is the biggest myth about FCS? Here it is. If I just tell the truth, everything will be fine. Well, the truth matters, but how you present information matters just as much. FCS mediators are trained to assess child-centered thinking, willingness to co-parent, emotional regulation, flexibility, insight into the child's needs. They are not there to decide who's the better spouse. They're there evaluating who is a safer, more stable, more child-focused parent. If you spend your entire session attacking the other parent, you may think you're proving something. However, what the mediator may hear instead is, this parent cannot co-parent. This parent is emotionally reactive. This parent is stuck in conflict. FCS preparation teaches you how to communicate concerns without looking combative. That's not manipulation, that is strategy. So, let's go over the most common FCS mistakes. I'm going to walk you through these mistakes I see constantly. First off, going in emotionally charged. If you walk into FCS angry, defensive, or determined to win, you will likely hurt your own credibility. Preparation includes emotional calibration. You must be regulated. Mistake 2 is bringing irrelevant grievances. FCS is about custody, parenting schedules, the child's best interests. It's not about who cheated, who was rude, who ruined holidays, who doesn't text back fast enough. If you focus on the wrong issues, you dilute your legitimate concerns. Also, no concrete parenting plan is a big issue. If the mediator asks you, what schedule do you propose? And your answer is, I just want what's fair. That's not a plan. You need specifics, exchange days, times, holidays, school breaks, summer, transportation. Preparation forces you to think through logistics in advance. The fourth mistake I see is not understanding how you come across. Tone matters. Body language matters. Language matters. Saying he's a narcissist is different from saying I have concerns about communication patterns and how conflict is handled in front of the child. Preparation helps you translate emotional language into professional, child-centered language. And that alone can change perception dramatically. So, what does FCS prep actually include and what does it do? Well, FCS prep is not about rehearsing a speech. It's about clarifying your goals, identifying your strongest points, anticipating weak spots, practicing calm, focused communication, developing realistic proposals. It also includes reality testing. Sometimes parents want sole legal custody, but they don't have a legal basis. They want drastic reductions in time without evidence, restrictions that just won't hold up in court. Preparation means I can say that argument may not land well, or that concern is valid, but let's frame it properly. It's about strategy, not emotion. And here's something really important. When you prepare properly, you walk into FCS more confident. Confidence reduces anxiety. Reduced anxiety improves communication. And better communication improves outcomes. So, let's wrap it up with the cost of not preparing. What are those consequences? Well, if you walk in unprepared, here's what can happen. You might ramble, get defensive. You might overtalk, attack the other parent. Or you may just sit there and freeze. You may agree to something you regret. Or you fail to advocate for something really important. And once a recommendation is written, it's very hard to undo it. Judges give lots of weight to FCS. Not absolute weight, but significant weight. Fixing a bad recommendation later can be costly, stressful, and uncertain. Preparation costs far less in litigation over a preventable mistake. So why do I say FCS prep is mandatory? Well, it's because of this. If you truly care about your custody case, if you truly care about your parenting time, if you truly care about protecting your child's best interests, you cannot treat FCS casually. You wouldn't show up to a trial without preparation. You shouldn't show up to FCS without it either. Even one structured session can dramatically improve clarity, focus, and presentation. So if you have FCS coming up, don't panic, but don't wing it either. Be strategic, be child-focused, be prepared, because FCS is not about who tells the longest story. It's about who demonstrates stability, cooperation, and a child-centered mindset. That's what the FCS mediators are listening for. If you need FCS prep, feel free to contact me at my website at www.brianvictorlaw.com. You can also reach out with any topic you have for upcoming podcast episodes. So thank you for watching this episode of the Divorce and Child Custody Discussion. If this episode was helpful, please share it with someone who has an upcoming Family Court Services custody mediation session. And as always, you can find the podcast on Apple Podcasts, Spotify, YouTube, and wherever you listen to your podcasts. Until next time, stay focused, stay steady, and stay child-centered.